I was having coffee on my back deck when I saw Patricia Vandermeer marching across my lawn with a clipboard and a look that could curdle milk. It was 7:30 on a Saturday morning in Riverside, California, and I had been living peacefully in the Sunridge Estates community for exactly 8 months before everything went completely sideways. "Mr. Harrison," she called out, her voice sharp enough to shatter glass. "We need to discuss your multiple violations immediately." I set down my mug and walked to the edge of the deck, looking down at this woman who had introduced herself as the HOA president during my first week here. Patricia was in her mid-50s with blonde highlights that looked like they cost more than my monthly utilities, wearing a pressed linen pantsuit despite it being the weekend. She carried herself like someone who believed rules existed primarily so she could enforce them. "What violations?" I asked, genuinely confused. She tapped her pen against the clipboard with theatrical irritation. "Your mailbox is the wrong shade of black. The approved color is midnight obsidian and yours appears to be simply black. Your front lawn grass height exceeds the 2 1/2 inch maximum by at least a 1/4 inch. And your garbage cans were visible from the street after 7 a.m. on Thursday, which is a direct violation of Section 12, Paragraph 4 of our community guidelines." I stared at her, waiting for the punchline that never came. "You're serious. Completely serious. I'm issuing you a formal warning. If these violations aren't corrected within 72 hours, you'll receive a fine of $500 per violation." That was my first real interaction with Patricia Vandermeer and the Sunridge Estates HOA board. I should have seen it as the warning sign it was, but I was still naive enough to believe that reasonable people could be reasoned with. I bought the correct shade of black paint for my mailbox that afternoon, mowed my lawn down to exactly 2 1/4 inches, and made sure my garbage cans were tucked away in the garage by 6 a.m. every Thursday. For 2 weeks, I heard nothing. Then the letters started arriving. The first one informed me that my living room curtains were visible through my front window and were not on the approved list of window treatments. The fine would be $300 if not corrected within 5 days. The second letter arrived the next day, stating that my car was parked at an improper angle in my driveway, creating an aesthetic disruption to the neighborhood. Another $300 fine. The third letter claimed that I had placed my recycling bin out on the wrong day, despite the fact that I had photographic evidence on my phone showing it was the correct day. I decided it was time to attend an HOA board meeting. The meetings were held on the second Tuesday of each month in the community center, a beige building that looked like every other HOA facility in Southern California. When I walked in that September evening, I found about 15 other homeowners scattered across folding chairs, most of them looking either bored or defeated. Patricia sat at a long table at the front with 4 other board members, all of them middle-aged and wearing the kind of clothes that suggested they spent their days playing tennis and their evenings finding new ways to make their neighbors miserable. "We have a new attendee," Patricia announced when she saw me, her smile not reaching her eyes. "Mr. Harrison, how nice of you to join us. Please hold any questions until public comment period at the end." I sat through 45 minutes of the most mind-numbing bureaucratic nonsense I had ever witnessed. They discussed the font size on the community newsletter for 12 minutes. They debated whether the pool hours should be adjusted by 15 minutes. They argued about the shade of mulch that should be used in the common areas. Finally, they opened the floor for public comment. I stood up. "I've received multiple notices about violations in the past few weeks. Some of them seem excessive, and at least one of them is factually incorrect. I have proof that my recycling was put out on the correct day." Patricia's expression didn't change. "Our community standards exist to maintain property values for everyone, Mr. Harrison. If you disagree with a citation, you may submit a written appeal within 10 days of receiving the notice. All appeals are reviewed by the board. So you review appeals against your own decisions. That's correct. And where can I find the complete list of these standards? I've read the documents I received when I bought the house, but some of these violations aren't mentioned in there. A board member named Richard spoke up, his voice dripping with condescension. The CC and Articus are supplemented by board decisions and community standards that evolve over time. It's your responsibility as a homeowner to stay informed. How am I supposed to stay informed about rules that aren't written down anywhere? Patricia's smile grew tighter. Perhaps you should attend our meetings more regularly. Now, if there's nothing else, we need to move on. I submitted written appeals for all 3 fines. All 3 were denied within a week. The letters informed me that failure to pay the fines within 30 days would result in additional late fees of $100 per violation, plus interest calculated at 18% annually. I paid the $900 because I didn't know what else to do. I was a mechanical engineer, not a lawyer, and I had just started a new job with a defense contractor in nearby San Bernardino. I didn't have time to fight with my HOA over curtains and garbage cans. But Patricia Vandermeer was just getting started. In October, I received a notice that my front door wreath violated community aesthetics standards. I didn't have a wreath on my front door. When I called the HOA management company to point this out, they told me to submit photographic evidence with a written appeal. I did. The appeal was denied because, according to Patricia's response letter, the photograph was taken after the violation had been corrected, so it proved nothing. In November, I was cited for having an unauthorized vehicle parked in my driveway. The unauthorized vehicle was my truck, the same truck that had been parked there since I moved in. Apparently, trucks were only allowed if they were parked in the garage or if they had a special permit. Nobody had mentioned this before. The fine was $750. I started doing research. I found online forums filled with homeowners from across the country sharing horror stories about their HOAs. I learned about selective enforcement, arbitrary rules, and boards that operated like petty dictatorships. I discovered that in California, HOAs had significant legal power, including the ability to place liens on properties for unpaid fines. That knowledge became terrifyingly relevant in December. I came home from work 2 days before Christmas to find a certified letter taped to my front door. Inside was a notice informing me that I had accumulated $17,000 in fines, late fees, and interest over the past 4 months. The letter included a detailed list of violations, many of which I had never been notified about. According to the document, I had been cited for everything from improper holiday decorations to excessive noise to having the wrong style of house numbers. I hadn't put up any holiday decorations. My house was one of the quietest on the block, and my house numbers were the same ones that had been there when I bought the place. The letter concluded with a warning that failure to pay the full amount within 30 days would result in the HOA filing a lien against my property. That was when I hired a lawyer. Marcus Chen was a real estate attorney in Riverside who specialized in HOA disputes. He was in his early 40s, spoke quickly, and had the kind of energy that suggested he ran on coffee and righteous indignation. When I showed him the stack of violation notices and the demand letter, his eyes widened. "This is excessive even by HOA standards," he said, flipping through the pages. "Some of these violations are clearly fabricated. Others are so minor that any reasonable board would have issued a warning instead of a fine, and the amounts are way out of proportion. Can they actually put a lien on my house for this? Technically, yes, if the debt is legitimate, but that's a big if. We need to look at your governing documents, the meeting minutes, and any correspondence you've had with the board. I also want to know if other homeowners are being treated the same way." Over the next 2 weeks, Marcus and I built a case. He obtained copies of the board meeting minutes through a formal request, which the HOA was legally required to provide. What we found was stunning. In the past 6 months, Patricia's board had issued over $200,000 in fines across the community's 80 homes. But the enforcement was wildly inconsistent. Some homeowners received fines for things that others did with impunity. And looking at the patterns, it became clear that Patricia had her favorites and her targets. I was definitely a target. Marcus sent a formal letter to the HOA in early January, laying out our position that the fines were excessive, improperly imposed, and in some cases completely fraudulent. He demanded that all fines against me be rescinded and that the HOA provide detailed evidence for each alleged violation. Patricia's response arrived a week later. Not only did she refuse to rescind any fines, but she also added $5,000 in administrative fees for my attorney's frivolous and burdensome request. The total amount I allegedly owed was now $22,000. "She's escalating," Marcus said when I showed him the letter. "This is actually good for us in the long run because it shows a pattern of retaliation, but it's going to get worse before it gets better." He was right about that. In February, I received a notice that the HOA board had voted to impose a special assessment of $8,000 per household for emergency repairs to the community pool. The assessment was due within 60 days. When I went to look at the pool, it was in perfect condition. I talked to other homeowners who confirmed that there was nothing wrong with it. One of them, a retired civil engineer named Tom Santos, told me he had served on the board 3 years ago before Patricia took over. "She's been running this place like her personal kingdom," Tom said. We were standing in his driveway, keeping our voices low as if Patricia might be listening from the bushes. The old board actually cared about the community. Patricia cares about control and money. You should see the management company she contracted with. Her brother-in-law owns it. That was interesting. Marcus immediately requested financial records for the HOA, including all contracts with vendors and management companies. The HOA fought the request, but California law was on our side. After threatening legal action, they finally produced the documents. What we found was a tangled web of financial irregularity. Patricia's brother-in-law's management company was being paid 3 times the going rate for HOA management services. A landscaping company owned by Patricia's cousin had an exclusive contract for the community, also at inflated prices. And there was no legitimate basis for the pool assessment. The money was going into a reserve fund that, based on the pattern of transfers, appeared to be funding Patricia's pet projects and possibly lining the pockets of board members. "This is fraud," Marcus said, his voice tight with anger. "We're not just talking about improper HOA management anymore. This is potential embezzlement. We need to expand our approach." By this time, my total alleged debt to the HOA had climbed to $34,000, including the pool assessment and mounting late fees. I hadn't paid anything since hiring Marcus, following his advice that paying would be seen as an admission that the charges were legitimate. In March, the HOA made good on their threat. They filed a lien against my property for the full $34,000, plus legal fees they claimed to have incurred in pursuing the debt. The lien amount was $41,000, but they didn't stop there. In April, I received notice that the HOA was initiating foreclosure proceedings against my home. Under California law, an HOA can foreclose on a property to collect unpaid assessments and fines, just like a bank can foreclose on a mortgage. They were actually trying to take my house because I wouldn't pay their fraudulent fines. Marcus filed an emergency motion to stop the foreclosure and simultaneously filed a lawsuit against the HOA, Patricia Vandermeer personally, and the other board members. Our complaint alleged fraud, breach of fiduciary duty, selective enforcement, harassment, and violations of California's Davis-Sterling Act, which governs HOAs in the state. We also filed a counterclaim to clear the lien and sought damages for emotional distress and reputational harm. The local news picked up the story in May. A reporter from the Riverside Press Enterprise wrote an article about HOA abuse, featuring my case prominently. Suddenly, I was getting calls and emails from other Sunridge Estates homeowners who had their own horror stories about Patricia and the board. Tom Santos organized a meeting at his house, and 23 homeowners showed up, all of them with complaints. "She fined me $6,000 because she said my rose bushes were the wrong color," said a woman named Jennifer Kowalski. "They're red roses. They've always been red. That's the color roses are. They tried to fine me because my daughter's car was parked in front of my house when she visited," added another homeowner, Marcus Wu. "Said it violated the guest parking rules. She was parked in my driveway on my property." The stories went on and on. What became clear was that Patricia had been systematically targeting homeowners who questioned her authority or who failed to show her what she considered appropriate deference. She used fines and harassment as weapons to punish people and maintain control. Marcus suggested that some of these homeowners join our lawsuit as additional plaintiffs. 5 of them agreed. We amended our complaint to include their cases, which strengthened our argument that this was a pattern of misconduct rather than an isolated dispute. Patricia responded by doubling down. In June, the HOA board passed an emergency resolution banning the 6 plaintiff homeowners from using any community amenities, including the pool, gym, and community center. They also restricted our access to the walking trails that wound through the development. When Marcus pointed out that this was illegal retaliation, Patricia's lawyer argued that the board had broad discretion to manage community resources. The battle lines were drawn. Discovery began in July, which meant both sides had to turn over documents and sit for depositions. Patricia's deposition was a thing of beauty, according to Marcus. He said she was condescending, evasive, and at times openly hostile. She claimed that every fine was justified and properly imposed, but she couldn't provide evidence for half of them. When asked about her brother-in-law's management company and her cousin's landscaping business, she insisted that there was no conflict of interest because she had disclosed the relationships to the board. "Did you disclose them to the homeowners?" Marcus asked. "That's not required," Patricia answered. "Did you recuse yourself from the votes to award those contracts?" Also not required. The board members' depositions were equally revealing. 2 of them admitted that Patricia made most of the decisions, and that they usually just went along with whatever she wanted. One of them, a nervous man named Gerald Hutchins, said he had raised concerns about some of the fines but had been shot down by Patricia, who told him he didn't understand how HOAs worked. Our expert witness was a retired judge named Barbara Feldman who specialized in HOA law. She reviewed all the documents and provided a scathing report about the board's conduct. According to her analysis, at least 70% of the fines issued against me had no basis in the governing documents, and the amounts were grossly disproportionate to any legitimate community interest. The pool assessment was unsupported by any actual need for repairs, and the foreclosure action was, in her words, "one of the most egregious examples of HOA overreach I've encountered in 30 years of legal practice." In August, the HOA increased their claim against me to $100,000. They argued that my lawsuit had forced them to incur substantial legal fees, and that I should be responsible for those fees as part of my debt to the association. It was absurd, circular logic that would have been funny if my house wasn't on the line. The local news coverage intensified. The story got picked up by a Los Angeles television station, and a reporter came out to interview me in front of my house. I explained the situation as calmly as I could, showing the camera the violation notices and the foreclosure filing. The reporter also tried to interview Patricia, but she refused to comment and threatened to call the police when the news crew showed up at her house. The publicity had an unexpected benefit. A state assembly member named Robert Tran, who represented our district, reached out to Marcus. He said he had been receiving complaints about HOA abuse from constituents across California and was considering legislation to reform the system. He wanted to know if we would be willing to testify at a committee hearing. We said yes. In September, Marcus and I drove to Sacramento to testify before the Assembly Committee on Housing and Community Development. I told my story to a room full of legislators and their staff, explaining how a simple dispute over mailbox paint color had escalated into a $100,000 claim and a foreclosure action. Other homeowners from across the state testified about similar experiences. The committee members seemed genuinely shocked by some of the stories. These organizations are supposed to maintain communities, not terrorize residents, Assemblymember Tran said at one point. We need to look at whether the current framework gives them too much unchecked power. Back in Riverside, our case was moving toward trial. The judge had denied the HOA's motion to dismiss, which was a good sign. He had also issued a preliminary injunction stopping the foreclosure proceedings until the case could be fully heard. But the HOA was still pursuing their $100,000 claim. We had a settlement conference in October. The judge brought both sides into his chambers and urged us to find a resolution. Marcus laid out our position. The HOA should rescind all fines, remove the lien, pay our legal fees, and agree to policy changes that would prevent this kind of abuse in the future. Patricia's lawyer countered with an offer that I pay $25,000 to settle the case, with no admission of wrongdoing by the HOA. So let me understand this, Marcus said, his voice tight with controlled anger. Your client makes up a bunch of bogus fines, tries to steal my client's house, and now wants him to pay $25,000 for the privilege of being harassed. We believe the fines were properly imposed under our governing documents, Patricia's lawyer replied smoothly. We're offering a discount in the interest of resolving this matter efficiently. The judge looked at me. Mr. Harrison, what do you want to do? I had been thinking about this moment for months. Part of me wanted to be done with the whole nightmare. I could pay the $25,000, take the loss, and move on with my life. But another part of me, the part that had been growing stronger as this case progressed, knew that settling would be wrong. It would let Patricia continue her reign of terror. It would tell her that she could get away with this behavior as long as her victims eventually got tired of fighting. I want to go to trial, I said. The judge nodded. Trial is set for January 15th. Preparing for trial consumed my life for the next 3 months. Marcus and I met several times a week to go over testimony, review exhibits, and prepare for cross-examination. We had binders full of documents, violation notices, letters, financial records, emails, meeting minutes, and depositions. Our case was straightforward. The HOA had imposed fraudulent fines, engaged in selective enforcement, retaliated against me for exercising my legal rights, and attempted to foreclose on my home based on fabricated debt. The HOA's defense was that they had broad discretion under the governing documents, and that all their actions were within the scope of their authority. They argued that I was a difficult homeowner who refused to follow community standards, and that the fines were appropriate consequences for my violations. Christmas that year was subdued. I had spent over $60,000 on legal fees at that point, draining my savings. The stress had affected my work and my health. I had trouble sleeping, and I had developed a twitch in my left eye that my doctor said was stress-related, but I also felt a strange sense of clarity. I was doing the right thing, not just for myself but for every homeowner who had ever been bullied by an HOA board that forgot it was supposed to serve the community, not rule it. On January 15th, we went to trial in Riverside County Superior Court. The courtroom was a modern space with blonde wood and uncomfortable chairs. Judge Catherine Morrison presided, a woman in her 60s with sharp eyes and a reputation for not suffering fools. The jury was a mix of 8 people, 4 men and 4 women, ranging from a young tech worker to a retired postal employee. Marcus gave our opening statement, laying out the case in clear, compelling terms. "This is a story about power and abuse," he began. "The power that homeowner associations have over the people they're supposed to serve, and the abuse that happens when unchecked authority meets personal vendetta. The evidence will show that Patricia Vandermeer and the Sunridge Estates HOA board systematically targeted Mr. Harrison with fraudulent fines, invented violations, and ultimately tried to take his home when he refused to submit to their extortion. We will prove that their actions were not just inappropriate but illegal, and we will ask you to hold them accountable." The HOA's lawyer, a polished man named Bradford Simmons, painted a very different picture. "Mr. Harrison moved into a community with established rules and standards," he said. "He chose to live in Sunridge Estates, which means he agreed to abide by those standards. When he repeatedly violated the governing documents, the board had no choice but to impose fines. When he refused to pay legitimate debts, they had no choice but to pursue collection. This case is simply about a homeowner who wants to avoid consequences for his actions." We spent the first week of trial going through the documentary evidence. Marcus walked the jury through each violation notice, showing that many of them were for things that weren't actually violations under the governing documents. We had blown-up photos of my house, my mailbox, my lawn, and my driveway, demonstrating that the alleged problems either didn't exist or were so minor that only the most obsessive person would care. The jury seemed engaged, taking notes and studying the exhibits carefully. I tried to read their expressions but couldn't tell what they were thinking. In the second week, we called witnesses. Tom Santos testified about the change in HOA management after Patricia took over. Jennifer Kowalski described her own experiences with bogus fines. Our expert witness, Judge Feldman, walked the jury through the legal standards for HOA governance and explained in painstaking detail how the board had violated those standards. Then it was my turn to testify. Marcus took me through my story chronologically, from the day Patricia showed up with her clipboard to the foreclosure notice to sitting in that courtroom. I tried to stay calm and factual, but it was hard not to let emotion creep into my voice when I described coming home to find the foreclosure notice or talking to my parents about potentially losing my house. Bradford Simmons's cross-examination was aggressive. He tried to paint me as a troublemaker who had moved into the community with no intention of following the rules. He asked if I had a problem with authority. He suggested that I was exaggerating minor interactions to avoid paying legitimate debts. "Isn't it true, Mr. Harrison, that you simply don't want to follow the rules that everyone else in your community follows?" he asked. "That's not true," I said. "I'm happy to follow reasonable rules, but I'm not going to pay thousands of dollars in fines for violations that never happened." "You just don't think the rules apply to you." "I think the rules should apply equally to everyone, and they should be real rules that actually exist in the governing documents, not made up on the spot by someone with a personal grudge." Judge Morrison sustained Marcus's objection to the argumentative tone, but I think the jury heard what they needed to hear. When Patricia took the stand, the atmosphere in the courtroom changed. She wore a navy blue suit and sat with perfect posture, her expression radiating confidence. Bradford Simmons walked her through the HOA's position, and she explained each fine with the air of someone describing basic arithmetic to slow children. Then Marcus stood up for cross-examination, and everything shifted. "Miss Vandermeer, how many homes are in Sunridge Estates?" 80. "And how many violation notices did the board issue in the year before you became president?" "I don't recall the exact number." "Let me help you. According to the meeting minutes, the board issued 32 violation notices that entire year. Does that sound right?" "If that's what the minutes say." "And in the first year of your presidency, how many violation notices were issued?" Patricia shifted slightly. "I would need to review the records. We reviewed them. The number is 307. Does that number surprise you?" Standards were not being properly enforced before I took office. I made it a priority to ensure compliance. Marcus nodded slowly. Let's talk about compliance. Mr. Harrison was fined for having a wreath on his door that didn't exist. How does that ensure compliance? If he removed the wreath before the inspection photo was taken, that doesn't change the fact that the violation occurred. Miss Vandermeer, 5 neighbors testified that they never saw a wreath on Mr. Harrison's door. Are they all lying? They may not have noticed it. Or it never existed and you made it up. Bradford objected and the judge sustained it, but the seed was planted. Marcus moved through violation after violation, forcing Patricia to defend the indefensible. She grew increasingly flustered, her composure cracking. At one point, she snapped at Marcus that he wouldn't understand the complexities of community management. I understand when someone makes up violations to punish people they don't like, Marcus shot back. Speaking of which, let's talk about your brother-in-law's management company. That line of questioning was devastating. Marcus showed the jury the contracts, the inflated fees, and the fact that Patricia had never disclosed the conflict to the homeowners. He demonstrated that the HOA was paying almost $200,000 a year for services that should have cost $60,000. When he asked Patricia where that extra money was going, she claimed it paid for superior service. What superior service justifies charging triple the market rate? We have very responsive management. Responsive to whom, Miss Vandermeer? To the homeowners or to you? The trial lasted 3 weeks. By the end, I was exhausted but hopeful. The jury had heard everything: the fabricated violations, the selective enforcement, the financial irregularities, the retaliation, and the attempted foreclosure. They had seen Patricia's imperious attitude and her inability to justify most of the fines. They had heard from multiple homeowners who described a pattern of abuse. In closing arguments, Marcus was brilliant. He tied together all the threads of evidence into a compelling narrative about corruption and abuse of power. He reminded the jury that HOAs exist to serve homeowners, not the other way around. And he asked them to send a message that this kind of behavior would not be tolerated. Bradford Simmons did his best, arguing that the HOA had acted within its authority and that the fines were justified by the governing documents. But his arguments felt hollow after 3 weeks of evidence showing otherwise. Judge Morrison gave the jury their instructions and sent them to deliberate. That was on a Wednesday afternoon. We waited. Thursday passed with no verdict. I tried to work but couldn't concentrate. Marcus called in the evening to say this was normal, that complex cases often took several days to decide. Friday morning we got word that the jury had a verdict. We rushed to the courthouse. My heart was pounding as we took our seats. The jury filed in, their expressions neutral. You could have heard a pin drop in that courtroom as the foreperson, the retired postal worker, stood up. In the matter of Harrison v. Sunridge Estates HOA, on the claim of fraud, we find in favor of the plaintiff. On the claim of breach of fiduciary duty, we find in favor of the plaintiff. On the claim of selective enforcement, we find in favor of the plaintiff. On the claim of harassment and retaliation, we find in favor of the plaintiff. My hands were shaking. Marcus reached over and squeezed my shoulder. We award compensatory damages in the amount of $153,000, representing legal fees, lost property value, and emotional distress. We further find that the defendant's conduct was malicious, fraudulent, and oppressive, warranting punitive damages in the amount of $300,000. The courtroom erupted in whispers. Patricia's face had gone white. Judge Morrison gavelled for order, but the jury wasn't done. We further find that the defendant must remove all liens against the plaintiff's property, rescind all fines, and reimburse the plaintiff for all amounts paid under protest. Additionally, we recommend that the court order an independent audit of the HOA's finances and impose supervision to prevent future abuse. Marcus was grinning. I felt like I might pass out from relief and vindication. Judge Morrison scheduled a hearing for 2 weeks later to address the jury's recommendations and to determine the final amount of damages, including attorney's fees under California's fee-shifting statutes that allow prevailing parties in HOA disputes to recover their legal costs. The news coverage was immediate and intense. The local press had been following the trial, and the verdict made headlines. Jury awards $450,000 in HOA abuse case, read the Riverside Press Enterprise. The Los Angeles Times ran a longer piece about HOA reform and cited our case as an example of what can go wrong when volunteer boards have too much power and too little oversight. At the damages hearing, Judge Morrison was thorough and methodical. She reviewed the jury's findings and the evidence presented at trial. She ordered the HOA to pay the full compensatory and punitive damages awarded by the jury. Then she addressed attorney's fees. "Mr. Chen, what are your fees in this matter?" she asked. Marcus stood. "Your Honor, my firm's fees through trial amount to $68,000. If the court awards fees, we would also request an additional multiplier given the importance of this case and the need to deter similar conduct." The judge turned to Bradford Simmons. "Does the HOA contest this amount?" Simmons stood reluctantly. "Your Honor, we believe the fees are excessive for a case of this nature." Judge Morrison's expression suggested she disagreed. "Mr. Simmons, your client put Mr. Harrison through 2 years of litigation over fabricated violations and attempted to foreclose on his home. The jury found their conduct was malicious and fraudulent. I find that attorney's fees are warranted, and given the egregious nature of the HOA's conduct, I'm applying a 2.0 multiplier. The HOA shall pay Mr. Harrison $136,000 in attorney's fees." She wasn't finished. "Additionally, I'm ordering an independent forensic audit of the Sunridge Estates HOA finances for the past 5 years. If the audit reveals evidence of embezzlement or fraud, I'm directing the parties to report those findings to the Riverside County District Attorney's Office. I'm also appointing a special master to oversee the HOA's operations for the next 3 years to ensure compliance with the law and the governing documents. The costs of the audit and the special master shall be borne by the HOA." Patricia stood up suddenly. "Your Honor, this is outrageous. We were simply enforcing our community standards." "Miss Vandermeer, sit down," Judge Morrison said coldly. "A jury of 8 citizens heard 3 weeks of evidence and unanimously concluded that you and your board engaged in fraud and abuse. You're fortunate that I don't have the authority to remove you from the board myself, but I suspect the homeowners will take care of that. This court is adjourned." The total amount: $300,000 in punitive damages, $153,000 in compensatory damages, $136,000 in attorney's fees. The HOA owed me $589,000, plus they had to pay for the audit and the special master, which would likely cost another $100,000. The forensic audit began in March, and by May, the auditors had found what Marcus and I suspected all along. Over the past 4 years, approximately $320,000 in HOA funds had been misappropriated through the inflated contracts with Patricia's relatives and through outright embezzlement. Patricia had been using HOA funds to pay for personal expenses, including a luxury vacation to Hawaii that she had disguised as a conference for HOA education. The auditors turned their findings over to the Riverside County District Attorney. In June, Patricia Vandermeer was arrested and charged with embezzlement, fraud, and grand theft. Her brother-in-law and cousin were also charged as accomplices. The news coverage was extensive. The same woman who had marched across my lawn with a clipboard to lecture me about mailbox paint was led out of her house in handcuffs. The other board members, facing potential liability, resigned immediately. An emergency election was held, and Tom Santos was elected as the new president. One of his first acts was to suspend all pending fines and conduct a review of every violation notice issued in the past 3 years. He found that over 60% of them were questionable or outright fraudulent. The HOA's insurance covered most of the judgment against them, but the association also had to take out a loan to cover the audit costs and the special master's fees. The homeowners were furious when they learned what Patricia had done, not just to me but with their money. Several of them apologized to me for not speaking up sooner or for believing Patricia's lies about me being a difficult resident. In August, Patricia pleaded guilty to reduced charges as part of a plea deal. She was sentenced to 4 years in state prison and ordered to pay full restitution to the HOA. Her brother-in-law and cousin received probation and had to return the money they had received through the fraudulent contracts. Assemblymember Tran's HOA reform bill passed the California legislature in September. It included provisions requiring greater financial transparency, limiting the amount HOAs can fine homeowners without judicial review, creating an easier process for homeowners to challenge fines, and establishing penalties for board members who abuse their authority. The governor signed it into law in October, and it was nicknamed Harrison's Law in some of the press coverage, though officially it was the Homeowner Protection Act of 2026. As for me, I got my money in November after the HOA's appeals were exhausted. I used some of it to replenish my savings, took my parents on a nice vacation to thank them for their support during the whole ordeal, and donated $50,000 to a legal aid organization that helps homeowners fight HOA abuse. I still live in Sunridge Estates. With Tom Santos running the board, it's actually become a pleasant community. The rules are reasonable and fairly enforced. The finances are transparent. People wave to each other in the street instead of looking for violations to report. My front lawn is exactly 2.5 inches tall, not because I'm afraid of being fined, but because that's actually a pretty reasonable height for grass. My mailbox is midnight obsidian black, and it looks great. My garbage cans are in my garage most of the time because I prefer it that way. And sometimes, on Saturday mornings, I sit on my back deck with my coffee and think about how close I came to losing everything because a petty tyrant with a clipboard decided she didn't like the way I parked my truck. I think about all the people who don't fight back, who pay the bogus fines and live in fear of their HOA boards. I think about how lucky I was to have the resources to hire Marcus and to see the case through to the end. The whole experience taught me that standing up to bullies matters, even when it's expensive and exhausting and terrifying. It taught me that systems of power, even small ones like HOA boards, need oversight and accountability. And it taught me that juries, regular people pulled from their normal lives, can see through fraud and abuse and deliver justice. Patricia Vandermeer tried to take my house over mailbox paint and garbage cans. Instead, a jury awarded me triple damages plus legal fees. Patricia went to prison, and the law changed to protect other homeowners from going through what I endured. Sometimes the good guys actually win. I still have the first violation notice Patricia gave me, the one about my mailbox being simply black instead of midnight obsidian. I keep it framed in my home office as a reminder of where this all started, how far it went, and what it took to make things right. When I look at it now, I don't feel anger anymore. I feel something closer to pride. I stood my ground, I fought back, and in the end, justice prevailed. Life in Sunridge Estates is peaceful now. The pool is open to everyone. The walking trails are beautiful. The community events are actually enjoyable instead of being Patricia's personal propaganda sessions. New homeowners move in and have no idea about the war that was fought just a few years ago to reclaim this neighborhood from a tyrant with a clipboard. And me. I'm just a guy who wanted to live peacefully in his house. I never wanted to be a test case or have a law named after my experience. I just wanted to drink my coffee on my deck, go to work, and not be harassed about the shade of my mailbox. But when I was forced to fight, I fought with everything I had. And that made all the difference.